Welcome back everyone to Criminal Law. In this lesson we're going to talk about the elements of a crime, and this is essentially outlining the next of our major topics for criminal law, which are essentially the elements for a crime, the different component parts that are required to show criminal liability. Now this isn't just the two main component parts, the sort of equation for criminal liability, which for those who don't already know, we're talking about the actus reus of an offence and then the mens rea of an offence, but also all of the more subsidiary details that exist in this particular vein as well. So this involves also talking about causation. This involves talking about omissions as a way of giving rise to criminal liability. It is also a way of talking about things relating to strict liability offences where mens rea is not necessarily a required component feature. So that's what we're going to cover when we talk about this whole general topic on the components of criminal liability. We will explain the process by which an individual is found guilty or not guilty of a particular of an offence as well during this process, and essentially just talk about how we find criminal liability. Now we're going to do so with reference to a variety of different crimes. So for example, in showing omissions or showing strict liability or mens rea or actus reus, there are various different crimes that we can examine, but we're going to try and limit our understanding of the specifics of those crimes to when we actually get on to looking at them in the future. So if, for example, we cover a case in this series on murder or sexual offences, we're going to try and look at the component elements of that case, which exemplifies, for example, the mens rea, or exemplifies the idea of an omission or causation, rather than the specific offence itself, which of course we will get to when we look at those offences in more detail as we go on through this series. When we find criminal liability, we find it through the circumstances when the prosecution, often done under the auspices of the Crown Prosecution Service, can show that that the defendant satisfies the elements of criminal liability, and that in addition to this, there are no valid defences to the conduct which was committed. So one of the things that people fail to recognise in some regard is that when we find criminal liability, we also have to take into account any kind of valid defence. So that has to also be shown as well. And so it means that there has to be the presence of the various elements of criminal liability, for the most part. We will get to strict liability in the future, and that the absence of a valid defence is also present. There is also no valid defence, whether this is a defence which is full or whether this is a defence which is partial. So some partial offences may not necessarily absolve criminal liability in its entirety, but may reduce criminal liability from, say, murder to manslaughter, for example. So we can divide criminal liability into its component elements, and then we can minus the valid defence. We will get to defences after we have covered the offences at the end of this series of lessons. So the question is, what are the elements of criminal liability? Well, this is a question that really depends on the particular crime that we're talking about. So when we go on to explore the nature of various offences and various crimes, we'll be able to divide them into their constituent parts and really find where criminal liability arises. This is really easy for, say, statutory offences. So when we look at, for example, sections 1 of the Sexual Offences Act, we can clearly just read it down and we can just highlight what are the different individual component parts of criminal liability for section 1 of the Sexual Offences Act. It's a little bit more difficult when we are talking about common law offences, because of course this is deriving out of the various principles of judge-made law, but it's not impossible, and it's not too much. It's not that difficult to establish. So when we look at criminal liability, the elements of criminal liability to the specific crimes will often fall into one of two main categories. They'll be defined by either the actus reus of an offence or the mens rea of an offence. Now, these are arguably the two most important principles that you should really understand before even examining any other element of criminal law. So that's why we're spending so much time examining them in this series. Beginning first then, the Actus Reus, the phrase itself, if we were to just translate it, simply means guilty act. And so, while this is true for the most part, it doesn't mean necessarily that an act is required to fulfill an Actus Reus for an offence. We will get to omissions in the future. But for now, the idea of an Actus Reus is the guilty act, essentially doing the thing that leads to criminal liability. So if it is murder, then it is doing the murdering, doing the actual physical act itself that is the guilty act. Again, when we say guilty act, that infers or implies that may have to be a positive act, a thing that you have to do. But criminal liability can also arise in certain circumstances out of an omission, i.e. failing to do a particular thing as well. So we'll get to that in the future. But fundamentally, the Actus Reus of a crime generally refers to the thing that is done where criminal liability is incurred. So if we are talking about theft, it is the appropriation, the appropriation of a particular piece of property. If it is, like I've said, murder, it is the sort of homicide element, the killing of an individual, ending a person's life. In conjunction with the Actus Reus, we also have to think about the idea of mens rea. Mens rea refers to the idea of a guilty mind, and it comes out of the Latin maxim of actus non facit reum nisi mensit rea, which essentially tells us that it means that essentially the fact is not guilty unless the mind is guilty. So there has to be a correspondence of Actus Reus and mens rea for a particular offence to give rise to criminal liability, for example. So it's not just enough necessarily in some circumstances to just have done a guilty act. One has to also do so with a guilty mind. It is also never enough to just have a guilty mind. You cannot be convicted of an offence because you had a guilty mind and you didn't actually perform the offence. The performance of the offence in conjunction with the mens rea is where criminal liability arises, in the majority of circumstances. Like I said, I'm going to put a little asterisk there because, of course, you also have strict liability offences as well, which take mens rea very little in. They're generally not that bothered about the mens rea in strict liability offences, and we'll get to that in the future. So, like I said, we'll get to this because there is not necessarily the requirement of a prerequisite mens rea in every single case. But generally speaking, if we were to then construct criminal liability, we can take all of these factors into account and we can construct criminal liability as the Actus Reus plus this idea of the mens rea, the guilty act plus the guilty mind, minus a valid defence, okay? So we're taking away any idea of a valid defence. There is no valid, because if there was a valid defence and that defence was full, then the individual will be found not guilty and there wouldn't be criminal liability. So it is the guilty act plus the guilty mind minus the valid defence, all of which gives rise to criminal liability. And this is the general structure in which we're going to look at the construction of the various crimes that we are going to examine. So when we look at murder, for example, we're going to do so by looking first at the Actus Reus, what are the requirements there, and then the mens rea, the correspondence of the two. There are some cases that are quite interesting in that regard. And then we'll talk about valid defences, and then also think about how that gives rise to criminal liability. The same with theft, the same with sexual offences, the same with dishonesty offences as well, and non-fatal offences, all of which are going to be constructed on the basis of this Actus Reus plus this mens rea, this guilty act plus the guilty mind. But for now and for the next lesson, we're going to begin by talking about Actus Reus in its general form, in its generality, by talking about what it actually means to have a guilty act, talk about the distinction between an act and an omission, talk about the idea of criminal conduct, talk about the causation of the conduct with reference to the liability that arises, before we then move on to talking about mens rea and strict liability, etc., etc. Welcome back, everybody, to Criminal Law. In this lesson, we're continuing talking about the elements of criminal liability, focusing now in more detail on the idea of Actus Reus, the first of the major elements, the idea of a guilty act. We're going to explore a number of different issues pertaining to the idea of the Actus Reus within this lesson, picking up on what we did in the previous lesson, which was introducing the subject of criminal liability, looking at the various elements of a crime which ultimately are required to show liability in question. So we talked, for example, the idea of the actus reus of offence, the idea of a mens rea, and the lack of a valid defence being the most common equation, shall we say, for the establishment of criminal liability. I also preface the fact that we are going to talk about strict liability in more detail in future lessons, and so that sort of skews the extent to which mens rea is particularly important in those particular offences. This lesson, like I said, is going to look in more detail at the first of these major elements, talking about the idea of actus reus within criminal law. I'm going to talk about actus reus for a few lessons. We're going to talk about it in its general form in this video, and then we'll start to talk about some of the subsidiary issues which relate to actus reus, talking, for example, about the concept of criminal intent, talking about the concept of omissions versus acts and the type of offences that can exist in that regard, and talking about the idea of causation, the idea that the act itself causes the harm for which criminal liability arises. So, like I've said, fundamentally, the concept of actus reus is the most important part of criminal liability, because if you don't have and you cannot show that there was a guilty act, you cannot show that there was a guilty individual. You cannot show that there was criminal liability at all. And the reason for this is because a lack of the actus reus, even if you have a prerequisite and you can show quite clearly that they have a strong mens rea, it means that the individual cannot have actually committed an unlawful act. And so this sort of goes into, dates back to the idea of the fact that whereas in some circumstances and in some types of criminal offences, you are not, you are liable even if you do not have the prerequisite mens rea. So the idea of strict liability, for example, when it comes to the actus reus, that is a requirement for any circumstance within a crime. You have to have committed an act in order for this to be unlawful. Or, alternatively, you have to have omitted to perform a particular action such that criminal liability arises. You can still have liability for omissions. The point is that you have to have either done something or been so negligent in not doing something that liability arises, ultimately. There has to be a physical thing that happens in order for you to have committed an unlawful act. And so, in addition to this, one cannot be convicted for simply just having a guilty mind. I might think in some circumstances that I want to kill an individual, but if I don't do it, then I cannot be convicted of murder, for example. This is illustrated very clearly in the case of R and Della from 1952. In terms of the facts of this case, I'll run through them quite quickly. Ultimately, the defendant was making an arrangement to sell a car, to make a sale on a vehicle. And the aim here essentially was to do and claim that the car had not had any kind of financial obligations that were outstanding attached to it. So the aim was to sell the car while falsely making the statement that there was no outstanding financial obligations, when in reality the defendant had taken a mortgage out on the car to a finance company. And so as a result of which was committing some kind of fraudulent act in doing so. But in reality, and without the defendant's knowledge, in fact, the agreement that was made, the agreement to take the mortgage out with the finance company, was actually void, and it had been void, meaning that there were no outstanding financial obligations on the vehicle. So he was making this claim that there were no outstanding financial obligations on the vehicle. He believed that he was acting fraudulently, but in fact he was just telling the truth. There weren't any outstanding financial obligations on the vehicle. And so when he was prosecuted for obtaining, for the offence of obtaining by false pretenses, which is just sort of an old-fashioned way of saying fraud, he was unable to have any criminal liability owing to the fact that he didn't actually commit a criminal offence. And so this this essentially solidifies the fact that while he had the prerequisite mens rea, he went out and he fully intended on committing fraud in this instance, or committing obtainment by false pretenses. He did not actually do so, and so he can only have had a guilty mind. He did not have the prerequisite mens rea, and so he could not be found guilty of that particular offence. When we think about the actus reus, we think about this idea that a person ought to have done the thing in question in such a way that was voluntary. So actus reus will require that the act is done and is done so voluntarily. And this relates to this idea of voluntariness. And the idea here is that if an individual has committed an offence and has committed an act, but not done so using their own free will and under their own physical capabilities, then no criminal liability may be able to occur. Take, for example, the case here of Bratty and the Attorney General of Northern Ireland from 1963. This is a passage that it comes out of that particular judgment. They say here that the requirement that the murder, should I say, the idea of the offence itself that was in question in this particular case, should be voluntary, should be a voluntary act, is essential, not only in a murder case, but also in every criminal case. No act is punishable if it is done involuntarily. And an involuntary act in this context means an act which is done by the muscles without any control by the mind, such as a spasm, a reflex, or a convulsion, or an act done by a person who is not conscious of what he is doing, such as an act done while suffering from a concussion. So, for example, if an individual has muscle spasms and they accidentally slip, and maybe accidentally slip and hit an individual in the face, or punch an individual in the face, they cannot therefore be charged with an assault or battery or an ABH, for example, because of the fact that it was done by a reflex or a convulsion or a muscle spasm. It was done not voluntarily. It was done just as a sort of muscle spasm that had no connection to the mind itself. And in a similar way, if you do something while you're unconscious, then again you cannot be considered to have committed an offence. You may think, for those who have already gone through some of the criminal law stuff already, that this pertains to a particular defence within criminal law, a particular capacity defence called automatism, and you'd be right. This idea of automatism fits very much within this idea of involuntarily making and doing a particular act which could give rise to criminal liability. There are plenty of examples that exist, for instance, when we talk about the idea of when certain individuals play rugby and they get hit in a particular way, they can sometimes continue running while completely unconscious and then run into another individual. If that happens, that individual cannot be criminally liable for that particular offence, and so as a result of which you make the argument that they can be, at least there could be the defence of automatism in that regard. In some circumstances, when we think about looking at a delineation between the actus reus and the mens rea of an offence, this isn't necessarily always clear-cut. In some offences, you can take a statute, you can take a provision within a statute, you can just read it down, and you can almost have two highlighters. You can have an actus reus highlighter, and you can have a mens rea highlighter. And you can sort of highlight where the actus reus exists within that offence, and then you can then highlight where the mens rea exists in that offence. And I would recommend for anyone who is studying criminal law in those circumstances to actually do so, because that's a very good way of being able to make a clear division within the criminal law. And especially when you have problem questions, it's good to unpick and unpack the actus reus and the mens rea elements to then apply both of them individually into the circumstances of the particular problem question. Now, there are some instances, however, where this is not always clear-cut, and it can be argued, for example, that in some offences, the actus reus includes mental elements, and a prime example here is the crime of burglary, because this is an offence which requires an actus reus, which requires trespass to land, for example, but it also requires something else. It requires that there has to be an intent to commit further offences. And this is, of course, the intent to commit theft. And this is connected to this idea of trespass to land. So you have an instance here where we have trespass to land in and of itself isn't burglary. And so that if there isn't an intention on the part of the trespasser to then go on to steal or to commit theft, then there is no mens rea element, but there's also no actus reus element for the crime of burglary. So you have an instance here where the trespass in question, the act itself, has to be done so with an intent to commit further offences. So this clear dividing line that exists between the actus reus and the mens rea isn't always so clear cut. It isn't always so easy to make this delineation. In a lot of offences it is, but in some cases it is not. In this video, we're continuing to talk about the concept of actus reus, which is pertaining to and related to the idea of elements of a crime and criminal liability. In this video specifically, we'll talk about this idea of criminal conduct, making distinctions between voluntariness and automatism, making distinctions between acts and omissions as well. These will be useful for our adventures, shall we say, into some of these concepts in more detail in future lessons' time, and to concepts such as things like causation as well. So we're talking in more detail in this lesson about the idea of criminal conduct in relation to the actus reus for a criminal offence. And we're talking firstly about the concept of acts versus omissions. So ultimately, we remember from our previous lesson that the concept of actus reus refers to the idea of a guilty act. The idea here is that in order for you to be held liable under some kind of criminal offence, whether that be a statutory offence or a common law offence, you have to have done a thing or not done a thing such that liability is incurred onto you. You cannot be simply guilty for having a mental state, for having a guilty mind. I can think as much as I like about committing crimes, as long as I don't actually do so with the guilty mind. I'm okay. The police are not going to be able to arrest me for thinking about committing crimes. Instead, you have to have the guilty act. Now, as we mentioned in previous lessons, we know that the actus reus of an offence needs not require the criminal conduct, the thing itself, to be an act. In some cases, and in certain offences, it may even be the case that a serious omission can give rise to criminal liability. So an omission is simply a failure to act. So rather than you doing and performing a positive act, rather than you going and doing a thing, an omission is you failing to do something such that the result leads to something which could give rise to criminal liability. And the standard and the burden that is placed here is a little bit higher than an act itself, given the fact that in certain circumstances you are not held liable for all of your failures to act in a particular circumstance, but mainly if there is something of a duty of care for you to have acted, and you have omitted to act in a serious way. You've omitted to do something. That's when we can see that we can give rise to criminal liability. So given that an omission is a failure to act in a particular circumstance, there is a certain number of instances where a crime cannot be committed by an omission. So for example, robbery, by the very definition of the offence itself, cannot be done through an omission. You cannot omit to do something which then gives rise to you committing robbery. You can't, that can't happen. Okay, robbery requires a positive act. In other cases, though, we can see omissions giving rise to criminal liability. One such example, and a number of key cases in this field, in this particular area of criminal law, relates to the offence of murder. A murder can be committed either by act or by gross omission, okay? Not by just any omission, not just by a failure to act in a particular circumstance, but to fail to act in such a way so as to give rise to criminal liability. So there's something of a relatively high standard, a relatively high bar. Assuming that there is the prerequisite mens rea, of course, attached to these conducts, which is what we are doing for all of these lessons on actus reus. We're just going to assume that we can show mens rea and that there are no defences for the time being while we talk about the acts themselves. A defendant may be liable for murder if they say committed an act which kills the victim, Alternatively, they may be liable if they, intending to kill the victim, leave them in a situation where they will die. So there has to be a certain situation where an individual may die. If there is not this intent, obviously then we can start thinking about the delineation between murder and manslaughter, or even if there is no, even if liability is so far removed that there may not be any kind of criminal conduct at all. But if you intend to kill a victim, you intend to kill an individual, and you create the circumstances, or by failing to act in a way, you create the circumstances where they die, and that was your intention in doing so, in failing to act in a particular way, then you are guilty and can be guilty of murder. A key case in this regard is from the case of Gibbons and Proctor from 1918. Ultimately, we have two defendants. So we have a defendant and a party to the crime, D1 and D2. These were both parents. The defendant was the father of the victim, and the second defendant, the secondary defendant, was the stepmother of the victim, such that essentially both D1 and D2, D1 was the parent, an actual father, but the D2 also had de facto parental responsibility, while not necessarily being biologically related to the victim. They still had parental responsibility. The two had both failed deliberately to feed the victim, and then the result of which was that the victim died. So there wasn't an act, there wasn't an attack, for example, or something that physically a positive act that caused the victim to die. There was an omission. There was a failure to feed the victim in such a way as to cause the victim to die. They were both, as you can probably rightly understand, they were both convicted of murder. The result here is that murder can be either an act-based offence or an omission-based offence as well. We'll get on to omissions in more detail in future lessons' time, so don't worry if we haven't covered it to the extent that you think is satisfactory. When we talk about voluntariness and automatism, on the other hand, we have this other issue that we have to deal with, because as mentioned in the previous lesson, the actus reus of an offence must be committed voluntarily, okay? And so if one is acting unconsciously, i.e., and as we mentioned in previous lessons, through muscle spasms, etc., then they cannot be held to have committed the act in question, okay? It has to be done voluntarily, and this gives rise to this question of automatism. And this, in fact, actually negates fully the actus reus of an offence. So rather than thinking about this in a different regard, it is often described as a defence rather than the negation of an offence. And we'll talk about this in more detail in future lessons' time, but one of the capacity defences that exists alongside insanity and intoxication, etc., is this idea of automatism. And we will get to this in more detail in future lessons' time, given the fact that it is often described as a defence, but in reality, we should probably think of it more akin to a negation of actus reus. Okay? Welcome everyone back to the criminal law. In this lesson, what we're doing is continuing talking about the idea of the actus reus of an offence, talking about the concept of criminal conduct, a criminal act itself, but we're going to be shifting our focus ever so slightly to moving away specifically from a positive act which is committed, which can give rise to criminal liability, to the general rule that is established for an omission to take place. So whereby we have an omission which gives rise to criminal liability instead. So we spoke briefly about the concept of criminal liability being something that can arise in certain circumstances out of either an act that is committed. That's relatively uncontroversial. If I, for example, go and commit murder, I go and do an act that I intentionally killed somebody, then that is obviously murder. The same can be said for things like sexual offences as well. But there are also different rules and liabilities that can exist for individuals who have omitted to perform a certain action, which gives rise to criminal liability. So we noted that it can be described in a way as almost the failure to act in a particular circumstance, and it is in that circumstance that we can see criminal liability arise out of an omission. We're going to take a more full and comprehensive study of that particular issue in this lesson, talking about the law pertaining to omissions, and then in the final 2 lessons on the Actus Reus of an offence specifically, we'll talk about causation, and we'll talk about how causation operates within the criminal law. So we already know what an omission is. Now let's just think about the general rule for how omissions can be applied, or at least the examination of an omission, which would be, as applied, create or negate criminal liability. So the general rule is that the criminal law does not criminalize the failure to or the lack of an action in a particular circumstance. So the bar is essentially a little bit higher for omissions versus for acts. There isn't this criminalizing of the failure to do something in all general circumstances. However, this does not mean that criminal law doesn't criminalize omissions entirely. There are omissions where there is criminal liability. It just doesn't criminalize omissions in the general form. There are a number of reasons why this is the case. Why it is the case that the criminal law should not be seen to just perform an overarching criminalization of the failure to act or the lack of an action in a particular circumstance. In some circumstances, for example, it may be difficult, nigh on impossible, to even prove the causation. So when we think about an act itself, there's a lot more of a clearly established causal link that you can really find between an act committed and the crime that is identified. But when it comes to an omission, then it's a little bit more difficult. And so as a result of which, if it's difficult to prove the causation from a failure to act, then it therefore means that it is difficult to prove any kind of potential criminal wrongdoing. In a similar way, it also seems to violate the general principle of autonomy, which is respected in law generally, respected that we have, as autonomous individuals, the ability to make decisions about what to do in a certain particular circumstance. So to suggest that to fail to do and to perform an act in a particular circumstance gives rise to criminal liability would seem to be a violation of this general principle of autonomy. It would also be very difficult to uphold and enforce a general rule for omissions which criminalizes any conduct which pertains to a failure to act in a particular circumstance. And so the general rule that we would identify is that there is no criminal liability for omissions. However, when we have a look at the various exceptions to this rule, we can see where the bar is set and where the standard exists for this particular area of law. So there are exceptions to the rule of omissions, such that a prosecution may be able to show criminal liability for a failure to act if the following conditions have been met. Firstly, it has to be shown that the offence in question is able to be committed by way of an omission. So there are some offences that just cannot be committed through omissions. So robbery, for example, is cited here on the screen. But murder, on the other hand, could be committed by way of omission. So we have to have the right offence to begin with. And if you were doing a problem question, that is probably the first place that you would begin. You would read the problem question. You would look for the failure, if there is an omission as an issue. But then you'd have to think, well, what is the offence in question? Is the offence in question capable of being committed by way of an omission? If it's robbery, then the answer would be no, and there would be no liability. It doesn't even necessarily make sense to suggest that there could be liability for someone failing to do something which leads to a robbery taking place. But on the other hand, of course, some very key examples that we're going to see in the future, in the rest of these slides, relates to murder, for example, or manslaughter. So the second question is, assuming that we have identified an offence which could be capable of being committed by way of an omission, we then have to show that the defendant in question had some kind of legal duty to perform an action. This can either be a common law duty or a statutory duty or even a contractual obligation in some potential circumstances. So we will get to, in future lessons, things like gross negligence and gross negligence manslaughter. This can be done where there is a legal duty for the defendant to perform an action. A lot of these things take place in medical cases, for example. And then we have the third requirement, which is that the defendant had this legal duty, but then breached this legal duty by failing to act in the way that they were legally bound to do, and that this failure to act can be shown to have caused the harm in question. Okay, so you might think that this is quite similar to identifying causation and to identifying liability in negligence cases, in either gross negligence cases within the criminal law or even just negligence within the law of torts. There has to be some kind of legal duty, there has to be a breach of duty, and there has to be causation. And it is similar in that regard. But of course, we're not talking about an act, we're talking about an omission, the failure to perform an act, which gives rise to criminal liability. Now let's cite a few examples in the case law. Now this is a non-exhaustive list of cases that we can think of. Some of these are particularly landmark cases, so are very important for you to understand. Some of them are relatively recently as well, and so also have some kind of relevance to you as well. So the first is this 1977 case of Stone and Dobson. The facts of this case are as follows. It involved two defendants. Again, we have two defendants, D1 and D2. D1 was the sister of the victim, and D2 was the partner of D1. So we have the sister and and then we have the sister's partner, and they were both. That's how they had a relation to the victim. The victim themselves were anorexic, and as a result of which had refused to eat. They suffered from the eating disorder, which is anorexia, and therefore refused to eat as a result. Now, the victim had also, it should be noted, been under the care of both the defendants for two major reasons. So firstly, they had voluntarily taken up the job of caring for the victim, and also the victim was living in their house. So we have a proximity to the victim in the sense that they were both living, all three of them were living in the same house, but then they had also voluntarily taken up the job to take care of the victim. The Court of Appeal held that there was therefore a duty of care owed to the victim on the parts of D1 and D2, such that when the victim died, the pair were convicted of manslaughter. So there was a legal duty to act in a particular way, which would be in a way to ensure that the victim did not die of anorexia, and that this was breached as a result of their failure to act in that particular way, and that failure to act in that particular way causes the harm in question, causes the victim to eventually die from their condition. And so as a result of which, you can see here that criminal liability does arise in the case of a failure to perform a certain action, therefore the failure to do something, an omission. In 1983, we have the case of Miller. This was a case which highlights the fact that liability may arise in circumstances where the defendant created some danger and then fails to act accordingly to try and prevent said danger. So the facts of this case are quite interesting. The defendant was a squatter who had smoked a cigarette in the premises in which they were squatting and then proceeded to fall asleep. When he woke up, he noticed that a fire had started as a result of his lit cigarette that had not been put out properly. And so at this point, okay, there isn't necessarily in and of itself an indication that criminal liability may arise out of these facts. But what follows is where the criminal liability comes from, because the defendant did not take any precaution or measure in order to try and put the fire out. And so as a result of which, the House of Lords made it very clear that the legal duty to act had been instigated at the point when the defendant had woken up and then realised that there was a fire that had been taking place as a result of his own actions. And so any ordinary circumstance in that particular regard would suggest that the defendant would probably act in some kind of way to try and put the fire out, maybe call the fire brigade, do something in that to try and reduce the damage that was caused by this fire. But given the fact that the defendant didn't do anything, they just got up and left, by all accounts, then this was considered to be a breach of this legal duty to act. The defendant was under a duty to act in such a way as to try and prevent or extinguish the fire. Now, it should be noted that if the defendant was if the defendant wasn't particularly successful in doing so, this doesn't necessarily mean that criminal liability automatically exists there as well. It is the fact that they had this duty and they didn't do the thing that they were supposed to have done, and that's where the liability arises out of this omission. In 1993, we have the case of Bland. Now, this was a case involving a Mr. Bland who had been seriously injured in the Hillsborough Stadium disaster. For those of you who are too young, do not remember the Hillsborough Stadium disaster, Google it. It wasn't a particularly nice event that takes place. And in fact, we're going to get on to looking at the Hillsborough disaster when we do the law of tort, and we talk about secondary victimhood within psychiatric injury, because there's a case that comes up in that regard as well. So, Mr. Bland had been in a persistent vegetative state since the accident, and the doctors who were looking after him believed that the right course of action and the best interests of the patient would be to remove life support and allow Mr. Bland to die. Now, the solicitor for Mr. Bland argued that this would be murder by omission, and it would also represent a breach of the doctor's duty of care, because, of course, they have a doctor will recite a Hippocratic oath to protect and to try and preserve the lives of anybody who fall into their care. But in this case, they were making the argument that it is actually in the best interest of the patient and the right course of action to allow Mr. Bland to die. Now, when the case reached the House of Lords, the appeal would be dismissed, and it was held that the removal of life support and the withdrawal of further care would be an omission, but it would actually be a lawful omission, under the general rules that the doctors were acting in the best interest of the patient. And Lord Gough actually argued that by simply omitting to provide care, the doctors were acting lawfully, but by acting in a way which would bring about the end of Mr. Bland's life, by actually doing an act that would kill Mr. Bland, this would represent euthanasia, and of course euthanasia is unlawful in the United Kingdom. In 1979, we have the case of Crown and Datham. This was a case which involves a duty on the part of a police officer and the failure to perform that duty, which leads to a particular harm and therefore misconduct allegations made as a result of the omission. The police officer in question had witnessed from around 30 yards away a group of bouncers who had beat up an individual in the street, essentially. This individual was allegedly causing trouble, making some kind of noise, or essentially causing some kind of trouble within the nightclub. They were removed by this group of bouncers, and the group of bouncers, in fact, had beaten this person to death after they were ejected from this nightclub. And they had done so in full view of this police officer who had witnessed it from around 30 yards away. The police officer failed to do anything about it, and so they were convicted of the common law offence of the misconduct of an officer for failing to perform an action in this particular case. Finally, then, we have the 2020 case of Crown and Broughton. Now, this is a case which involved a Mr. Broughton, who was the defendant, who was a rapper who had supplied his girlfriend with some Class A drugs while at a music festival. Now, in addition to the supply of drugs, the defendant had claimed to have altered the drugs to potentially increase their effects. This is considered to just be an additional factor within the facts of this particular case. When the victim had then began to take an adverse reaction to the drugs and began to convulse and collapsed ultimately, the defendant didn't alert the relevant authorities or even call for help in any way. Instead, what the defendant had done was actually just film the victim and then spoke to her parents about what was happening. So rather than calling an ambulance, rather than calling some kind of first aid individual at the music festival in question, he decided to film the victim and then also speak to her parents about it, who allegedly, and on the basis of the facts of the case, were pleading with the defendant to call an ambulance. Now, according to expert medical testimony during this case, if the defendant had gotten the victim seen to at an earlier point, then there may have been up to a 90% chance that the victim would have survived. So time was really of the essence in this particular case, such that if the defendant had actually acted swiftly in calling the right authorities when the adverse reaction to the drug was taking place, then there was a very high likelihood that the victim was actually going to survive this particular overdose. And so as a result of which, and the lack of the omission to actually perform in any kind of way, it was held that the defendant would be convicted of gross negligence manslaughter for his failure to act in the given circumstances.